Welcome to Looking at Legal Stuff. Today we have 7 hearings with a couple where mom was ordered last January to have a mental health assessment and share documents with dad in order to create an initial parenting plan. Mom drags her feet all year and has a million excuses why she isn't doing what was ordered. Now it's December and the judge has had enough of her antics. Let's watch.
All right. Any other quick matters, setovers, strikes?
I was going to see if we could do a continuance for Anderson and Erickson. I was late serving because I'm not represented. And I had to get help through Northwest Justice, the women's shelter, along with having a baby and my toddler. I was late and I feel really bad about that. I wasn't sure how to ask.
That's okay. Ms. Winkles, I see you here this afternoon. You're representing Mr. Anderson in this matter.
Yes, Your Honor, and I would ask that it not be continued. Ms. Erickson, we have, between my client, he has separate cases with her as well. She was able to file a petition in those cases, which meant she chose to do that rather than answer these. So she's self-represented in both and chose to put in 20 pages into one and none in the other. I would ask that this go forward today. She's had plenty of time. We actually gave additional time. We've been here before. We're here on a motion to compel next week. We were here last week. At some point, the delays need to stop. So I ask that we go forward. I don't mind if she argues something that's not written down. I would just rather get a temporary parenting plan. My client hasn't seen his child since she was born. The GAL report is in. So I don't think there's anything that limits us, especially if she's able to.
All right. Any response to that, Ms. Erickson?
I have a lot to say to that, but I'm not sure if it would be appropriate or not. But the whole motion to compel thing was on because of her behalf, because she didn't send me the right paperwork. So I wasn't saying that I was supposed to call. It said the petitioner was supposed to call and it wasn't me. So that really wasn't on me. But I was just trying to be nice for the other side to read what I had sent. I'm not being represented. I wish I could be. I've been looking. I don't have the money to do it. I have 2 kids at home all by myself. I've been trying to get everything done that I can, and I tried to get it all turned in on Friday. I'm very sorry, and I'm not coming up with excuses or anything. I'm being honest.
All right. I understand both sides and wanting some resolution. We're on for next week, the 9th. I'm going to add this onto the 9th. So I'm going to give you 1 week to submit something. If you don't have anything submitted, then we're going to move forward.
Well,
regardless. I'm talking. Don't interrupt me when I'm talking. Sorry. Okay, Ms. Erickson, okay. That's not a good way to start off here. So if you submit something, great. If you don't, we're moving forward regardless. Is that fair?
Yes, I'm sorry.
All right. We'll see you on the 9th at 1 o'clock.
Thank you.
Thank you.
All right, next is Aaron Anderson and Brittany Erickson.
That matter is ready, Your Honor.
All right, and is Brittany Erickson here? Nobody is responding, so I've got a presentation of order, which I may not be able to do unless it's agreed to, but also a review hearing. So Ms. Winkles, why don't you bring me up to date?
Yeah, so I doubt you'll be able to do the presentation of the order. It would be a temporary order with a parenting plan and also a compel hearing. This is the review for the compel. Okay. And a review of the hair follicle. The hair follicle was done by both parties. We can set that for when the Judge Fassett gets back. But the compel has still not been handled. And so I would ask for a second order because the original one had, in any event, that's the oral order of the court that today we were supposed to have those documents by today. I've not received them. I suppose if I don't receive them by 5 p.m., I can wait and give you the order tomorrow. But in any event, I've received absolutely nothing. And there is a protective order that we agreed to at the last hearing that's in there. Still have not received a single document. So I'd ask that the second compel be signed by Your Honor.
All right. I did see that there was an agreement to a protection order or protective order relating to those documents. All right. Why don't you wait till 5 today? If you don't receive anything, then present an order to me tomorrow and I will take care of it.
Sounds good. Thank you, Your Honor.
All right. Thank you.
So can we set the other hearing over? I'm not sure when Judge Bassett's back.
Next week is closed, so we'll have to go to June 6th.
Fine.
So Anderson and Erickson will be put over to June 6th.
Thank you, Your Honor.
Looks like Anderson and Erickson. 2330001508.
And that matter is ready, Your Honor. We're here on presentation of the family law order and the parenting plan. They were provided to the court on May 22nd and provided to opposing party at that time.
Your Honor, Scott Roberts for Miss Erickson. I was just retained this morning and I reached out to Miss Winkle's office. We're getting a notice of appearance prepared today. And I have no objection to the hearing going forward, given that I was not present in the prior hearing.
Okay. I appreciate that. Thank you, Mr. Roberts. So Miss Winkles, what I have. It's a temporary family law order and parenting plan. Is that correct?
That's correct, yes. And Your Honor had ruled that the GAL, essentially what the GAL said in the parenting plan was to be instituted. And that's what I did. I just kind of took the language out. I think I did change one sentence around just for formality's sake, for, you know, so it read a little bit better, but other than that, it should be almost identical to what the GAL stated.
All right. I will sign off on these orders. I did review them before court.
All right.
Anything
you.
else we need to do on this matter today?
No, Your Honor. Thank you very much.
All right. Thank you both.
Thank you.
Anderson and Erickson, 2330001508.
That matter's ready, Your Honor.
Sorry for the delay, folks.
That's all right.
All right, we're on for pretrial. Oh, we're just on for pretrial.
No, we're on for a motion for contempt.
I don't have a contempt. I have pretrial management.
Oh, I thought we were on the
Contempt.
motion for contempt. Is that next week then?
I have
I have
a
it
show
next
cause
week.
contempt for 8:15.
Oh.
If you all
Had I
are,
known that, I would have just asked us to move that one to the other.
well,
I got them backwards.
are you, Mr. Roberts, did you think we were on for contempt as well?
No, I thought we were on for contempt next week.
Okay.
And I think you told me that, and I think I had them backwards in my mind. Which
I
is
feel awful making you guys wait this long then.
I
I'm
should have
sorry.
piped up and I apologize too. I was just letting the court do go in the order and I didn't know if Miss Winkles had somewhere else to be. So I'm sorry to both of you.
Oh, no, I'm
No, it's, we're all sorry. Well, as far as pretrial, since we'll be here next week, any issues, discovery issues, both parties ready to proceed at this point with readiness that I show is next. I have readiness on the 22nd and trial slated the week of the 28th of this month.
And I'm fine with that. I mean, I didn't get everything I wanted in the last discovery, but I think just setting this, getting this on for a trial, I think just having testimony will get everything out anyway. I don't think there's any documents that I'm missing per se. So I'm ready. I think we've even done an ER 904 already.
Mr. Roberts?
I think that's fine. I came onto the case fairly late, but I think given the circumstances that testimony and what happens between now and then should get us where we need to go. So with that said, we can move to the next date and see you next week.
Okay. Well, I again apologize for keeping you here for 2 hours on a pretrial, but I will see you next week and I'll do my best to call you at the beginning of the docket.
Thank you, Your Honor.
Thank
All
you,
right.
Your Honor.
Thank you. Have a good afternoon.
You too.
You too.
All right. Ms. Cutter, I don't show anything else. Is there anything else you see we need to address?
No, we've completed the docket.
And Your Honor, I have a quick one for you as well, I believe.
All right, and which case is that?
It's Anderson v. Erickson, 23-3-00015-08. We're here on the, I believe it's the fourth review of the motion to compel answers to discovery to interrogatories.
Is Miss Erickson present? Ellie Anderson, or Ellie Erickson, I'm sorry.
That's the child. That's Brittany Erickson is the
Oh,
respondent.
sorry. Is Brittany Erickson present?
And just so your honor's aware, interrogatories were served on January 12th, quite a long time ago. We had a CR 26I on March 6th. Still, we didn't have compliance. We filed a motion to compel back in March of 2023. Hearing was held April 18th. She was given 3 weeks to comply. She didn't. Attorney fees were given. We had a review on May 9th. Still 117 days had passed, still no answers. We had that review March 9th. She was given an additional 14 days and told that if she did not answer, that she would have, her pleadings would be stricken. She was given a protective order just for her address. She was given till May 23rd for that striking her pleadings from the record. She did not answer. They were stricken on the June 6th compliance order. This is, again, we did another CR 26I conference on June 2nd. She did not attend. She did have new counsel as of June. We did another notice to them. We showed them what the deficient responses were. We sent another motion to compel. It's been 265 days. She's not materially answered. We'd ask for her to be defaulted. The court has tried everything: attorney fees, striking from the record, not able to give testimony, additional time. It's been almost a year. She shows up, she doesn't show up, her counsel shows up. She had counsel for months, and we tried to get discovery and we were unsuccessful.
One of the things that I guess I'm concerned about is that I look at the declaration in support of the initial motion to compel back in March. And I realize that other judicial officers have ruled on this, but I'm being asked to find somebody in default. And I see respondent failed to answer said discovery, and a 26I conference was scheduled. Said date has passed and respondent has failed to attend scheduled CR 26 conference. There's a notice in the file about that. And I don't think that
we did have a conference. We've had 3 CR 26Is where she's not made it to 2 of them. One of them we did have. That's where she asked for the protective order. That was before the May 9th hearing. We agreed to protective order. We came to court. We agreed in court for the protective order. She was given 2 additional weeks to get that back, and she failed. So we have had a CR 26I again when she was with counsel. We did discuss discovery. We were also told that we'd have it back. We sent them out a deficiency letter, and again, nothing. So the first one, we sent a notice of CR 26I. The remainder of those we scheduled. And I have talked to Ms. Erickson. I have talked to her former counsel, Scott Roberts, but nothing ever comes of it.
So you actually had a CR 26 conference?
Yes, we had a CR 26I, and I believe it's in the declaration or it's in the order on this hearing. Bear with me. So she missed the May 24th, but she attended the earlier one.
The other thing is, that was my first concern. I'm also concerned that she's answered the interrogatories at this point, maybe not entirely to your liking.
They're materially deficient. We can't put on a trial. We don't know. She was given a protective order so that I could have the information, but we know nothing about the child's doctors, the child's school, daycare, her drug and alcohol history, her address. Most of those things are missing. Her income, I don't believe she's working, but I'm completely unsure. We did send out the notice. I have spoken to her.
I'm comfortable limiting her to her answers, but I'm not comfortable with the default at this point.
Okay, my concern is that I'm limiting her answers. My concern is she's not even going to show up for the trial. Would Your Honor, is there anything I can do to make Your Honor comfortable? Set this out 2 weeks, and because we already have her pleadings stricken, set this out 2 weeks and do whatever necessary in order to I just want the discovery, to be honest with you, because even if she's defaulted, it doesn't change that I have no idea any of the circumstances of this child's life or hers. I'd be more than willing to set this out, serve her again with it, serve her with a notice of CR 26I, give her the deficiency letter because she has received that through counsel, outlining exactly which questions she needs to answer. I'd rather have that than limiting her answers, to be honest with you.
Your Honor, this is GAL. I also had the same problems getting I've gotten nothing from her I needed except for the limited things in the report. Her attorney reached out to me asking me, and I gave him what I had. He goes, and it wasn't what he needed. So I also have the same problem.
Yeah, I think, at least for me, I think I would need probably a deficiency, a more specific deficiency letter as to, because I've got a large exhibit here, and I have to guess what, or make my own judgment as to what's sufficient and what's not, and it's a pretty extensive document.
Is Exhibit E of the motion, is that not sufficient enough? That was given to her counsel. It lays out exactly which ones are deficient and what she's failed to answer. And that was provided on August 7th.
Okay.
I can also maybe make a table showing the question and the.
That's fine. Let me look at it.
Okay. And just so Your Honor's aware, that was me paring down, taking out at least 50% of the questions that she hadn't answered and just getting to the things I absolutely had to have for trial. The original letter, I believe, is at C or D. It's considerably longer.
So you're proposing sending another deficiency letter and coming back in a couple of weeks? Is that?
Yes. Yeah, at this point, her pleadings have already been stricken. There's nothing she can do at a trial. But really, we still need the information, to make a parenting plan, even if she's completely out of the picture, aside from a default where I just, assume things. We need the information. So I would ask that we come back. I'll send her another deficiency letter. I'll outline exactly what needs to be answered. If Your Honor can give me a drop dead date on a date where I tell her you will be defaulted if it's not, received by such and such date, I would be more than happy to do that.
All right. October 31, I think gives her plenty of time.
And I will email her, mail her, and I'll provide proof of service of the same to the court much earlier than that date.
All right.
All right. Thank you, Your Honor.
Thank you.
All right. Since Ms. Winkles, I put you on the spot there, we'll go back to the Anderson and Erickson matters, 21-50007-308 and 2330001508. And it does look like we have Miss Erickson present now. So as to the 217308 matter, this is looks like the presentation of final order on a parentage determination. Just make sure I have the right numbers with the right things here. Miss Erickson, did you receive the proposed orders from Miss Winkles?
No, I have not. I haven't gotten any. I didn't even know about this. I thought we had court on the 19th.
Your Honor, if I may, we've been talking via email. I sent it to the same email that she responded to me this morning on. I sent all the documents.
I haven't seen it.
Okay, hold on.
And we also mailed them to her.
I haven't gotten them. But sorry, I was late on here too. I literally had no idea where I was supposed to go. And I guess I was sitting in the wrong Zoom.
All right, I do show that on the 19th, we have a review hearing for the 231508 matter.
And that's with all my stuff, right? That I was supposed to.
And then I have this, well, it was set on, it was on for Friday morning, December 8th. I was ill. So they set it to today's docket, the 12th. The 8th was set for presentation, is my understanding.
That's correct.
And we have final orders of the parental determination. So that's in the 21.
I was going to submit I seriously thought that we had this court hearing was supposed to be the 19th, and I was going to submit a parenting schedule thing, because you mentioned to me that I could do that, and then I finally am able to get help. And since I don't have an attorney, since he like completely bailed on me, I'm seriously lost. And I haven't felt comfortable enough to really talk with Aaron Winkles, except for when I was dropping off papers. I asked a few questions, but I didn't feel comfortable asking certain questions.
I can understand that this is probably an overwhelming process, and without legal help, it can be very daunting, and I appreciate that. I can't give you legal advice. Ms. Winkles can talk to you directly about some of this because you are unrepresented. We have, there was a summary. I'm still talking. There was a summary judgment granted on January 13th, 2023 in the 2150007308 matter. Then that was amended due to a Scrivener's error and re-entered, I think, in October of this year. So we're working off of essentially in this matter, and Ms. Winkles, please correct me if I'm wrong, but essentially just a final parentage order that we need to get entered because of that summary judgment that was frankly entered almost a year ago.
Yeah, and it should have been entered after, and I'm not sure if it wasn't attached or if it's floating around the court still. But we just submitted it again, essentially the final order. So it wasn't just the the MSJ order, which is kind of temporary in its way.
All right.
My daughter doesn't really know Aaron, like they're getting to know each other through reunification still.
This basically is an order that says that he's the father.
Oh, okay. I'm sorry. I don't understand anything. I'm sorry.
So as far as that matter goes, this is, I think, probably was just an oversight. I am going to enter the order in the 2150007308, the essentially a final parentage order indicating that he is the biological father.
And Your Honor, can we also make sure that Ms. Erickson knows exactly what the 19th is, so we don't have to continue or have any other issues with what's going on then?
I'm sorry. I don't mean to.
It should be the entry of final orders after you review whether or not Ms. Erickson has a collateralized mental health evaluation and a drug hair follicle. And then you were going to determine custody at that time for the final parenting plan.
Okay, so because it's that case that's on the 19th is also on today. That's the 23-3-0001508 matter.
And I thought it was actually for today. I didn't know we were on the 19th, so I thought it was all going to be
Okay.
today. But I'm fine with however Your Honor wants to do it.
I called this the court clerk, and they told me the 19th. So like I said, I was trying to get in something that my attorney, I kept asking him to do and he wasn't doing, if that makes sense. And I'm trying to get our $5,000 back to try to find someone to help me on top of everything else.
All right. So we had, long story short, this is my version of my recollection of what occurred. We had a bench trial back in October. And at that point, you were representing yourself. Ms. Winkles was representing Mr. Anderson. There was a lot of information provided by Mr. Anderson, not a lot of information provided by you, Ms. Erickson. The court, and it looks like I was the trial judge, the court allowed some leeway to basically get an evaluation.
Yes.
That the court has not received. And I believe I set a date.
I gave it to Miss Winkles on Friday. I was trying to,
and that's,
I was hoping.
And that's what I explained, that it's not, and you'll see my emails behind my declaration, Your Honor, that I've submitted to the court. I told Ms. Erickson that was not an evaluation. It was not collateralized. And I explained exactly who to call.
Hey, Ms. Erickson.
Sorry.
You need to stop talking over people. No one can hear anything. We've gone through this before. One at a time, please. When someone else is talking, please don't speak. I'll give you an opportunity. I give everyone an opportunity. So please hold on. Ms. Winkles, go ahead.
Yeah, so Ms. Erickson did sign an ROI so that I could talk to her counselor. I did speak to him and he told me that it was an intake and it was not an evaluation. So she came, he hadn't seen her for some months. So she came into the office and I informed her of that. I said, all you need to do is you need to call them, give them, Mr. Anderson's number. They will collateralize and they'll do an evaluation. You need to contact them today. I sent her 3 emails as well, telling her that it was not an evaluation. She did not have an evaluation, but she could get one through either Columbia Wellness or Core Health, and that Columbia Wellness would assist her as long as she called within 24 hours. And that's where I left it. I assumed I would get something. I did not get anything, and my client's not been called as of today. So I'm guessing one has not been done. The intake was from last year, I believe, or the beginning of this year.
All right. So since our trial on the 26th of October, Miss Winkles, and I'm not seeing anything in Odyssey, but that doesn't mean you didn't receive something. Have you received anything from Miss Erickson regarding a 10-panel hair follicle or a collateralized assessment between October 26, 2023 and today?
So no to the collateral assessment, but I did receive a sheet showing that she had taken a hair follicle. I don't know if, because it was so close to today's date, I don't know if they have the results of that yet. I can actually look because I can log into my system. But the evaluation, no.
All right. And my notes indicate, I'm talking now, Miss Erickson.
I'm sorry.
My notes indicated that all of that needed to be provided no later than December 8th at 5 p.m. Do you show anything different, Ms. Winkles?
No, that's what I showed as well. And I actually submitted a proposed order to the court from that hearing that stated the same thing.
All right. So Ms. Erickson, it sounds like May I explain? I'm asking you a question. My understanding, based on my review of everything, was that you needed to do At least those two things, get a collateralized evaluation and a 10-panel hair follicle between October 26th and December 8th. And I don't have either of those things. So please tell me why.
Okay, so so the reason why I have them right here in my hands, I honestly thought that I was supposed to give Erin Winkles hers by the end of her closing time at 5 p.m. And it was already later because what happened was I misplaced, because I already had those done and I gave them to Mr. Roberts. And he was supposed to turn in everything. Come to find out, he turned in nothing at all. So I had copies of it, and all of a sudden I can't find it, right? So I had to actually go to Columbia Wellness myself, and I went and sat there and while we reprinted off the evaluations and stuff, and one of these pages actually looks a lot different than what I was actually given on my other paperwork, to be honest. They say assessment, and I'm confused because Mrs. Winkles is telling me that, because I did my evaluations as far as I was concerned, and I guess the assessment or whatever isn't it, even though I was told that I did it. I'm so confused over that. But the reason I was going to do my parenting plan, I was getting help because you told me that I could submit one, and I didn't know I could. And I've been waiting and waiting, trying to get help through Northwest Justice and everybody. And I was going to turn everything in today before you guys closed. That was my whole plan. And I thought that we honestly had court on the 19th. I didn't, and I was confused when Miss Winkles, sorry, excuse me. I was confused when she told me, because I gave her a copy of the hair follicle receipt. They didn't have a 10 panel, so I chose to do a 17 panel to kind of go above and beyond and prove that I've been honest. And that should be emailed to Miss Winkles. It should have already been emailed because they said it takes up to 24 hours. And that should have already been done. They wouldn't give it to me directly, even though we're the ones that, like, my dad paid the $350 for. But so I had them sent to, I didn't know how to send them to the courts or how to. So I sent them to Miss Winkles in hopes that she would be able to, maybe direct me in some sort of way. Like, that's why I was going to ask her. And then they started looking at my babies, and I just kind of, like, we were talking about my two girls, and I completely
I do have the
spaced
negative. Just so you're all aware, I do pull it up now. She is negative on everything on the hair panel.
Thank you. I knew. Yep. I have almost 6 years clean and sober. So, okay. So, and then with the parenting plan, I've never done one before, ever. And that's why I was reaching out for help. I requested that Mr. Roberts help me get one in instead of just agreeing and everything. And he kept telling me, no, we're not going to, that's not what we're doing right now. No, that's not what we're doing right now. And until he, like, told me on September, literally on my daughter's birthday, September 19th, that he was no longer going to be my attorney. It is the day that he told me. And then that's when I found out at trial that he never turned in anything that I had submitted him. I gave him everything. Like, I gave him all the copies that I had. Like, I didn't have any copies for myself, and that was stupid of me. But I trusted that he was going to put those in, if that makes sense. and I kind of fooled myself. But I have the paperwork from Columbia Wellness. It's right in front of me. I was just needing help with the parenting plan since I wanted to do one, and he told me that it wasn't the time, or I have like all of his text messages saved.
Okay. I again appreciate the difficulties of navigating this without an attorney, and especially I do recognize that you were at one point represented, and that in September of this year that attorney withdrew, and we did have a trial in October. But I do want to stress that we already had a trial, so there's we can't have several bites at the apple. I gave an opportunity for you to get this information in. I asked that it be turned in by the 8th. It sounds like you have all that information now. We are currently set on the 19th for review. Miss Winkles, it sounds like, received the hair follicle and that was clean. So that is great news. So thank you, Miss Erickson, for that. Yeah. I'm not 100% clear that we are where we need to be for that collateralized evaluation. So my understanding, based on the information that Miss Winkles provided to the court, is that you did an intake, but you didn't do an evaluation. Intakes are not collateralized, meaning they don't get any information from anybody else about an intake. But once they actually do an assessment or an evaluation, that's when they can have collateralized information.
No, I have the assessment right in front of me. I'm sorry.
Well, if it still wouldn't be valid if other parties weren't able to weigh in on it, because that's what was ordered.
Oh no, Aaron's been in there, both of them. I've had them on collateral this entire time.
Miss Winkles, did your client
no. So this is not true. I spoke to
He's supposed to call.
Wait, it's one at a time.
Sorry.
Okay.
I'm sorry.
So I spoke to Mr. Sandecker, I believe was his name, who is the person that did it. He stated he hasn't seen her in months, and when she came in, she only did an intake, which everybody does. He stated that she had not done an evaluation at all. And that it had not been collateralized because it was just an intake. And that's what I told her. I even handed her the form back and I said, this is an intake. It's not a drug evaluation. You still have time though. If you call him on the phone and you ask him to do the evaluation, I've just spoken to him on the phone. He's willing to do it. And that was about, about a week ago.
That was how long ago? I'm sorry.
About a week ago, I'd say.
Okay. All right.
It was Friday or Thursday. I've been speaking.
Here's the problem. I'm done right now. Here's the problem.
I'm sorry.
I'm sorry. It sounds like you're doing what you need to do, but you're doing it at the very last possible moment, and frankly, after the deadline. And I don't have this evaluation. I'm going to absolutely take Miss Winkle's word for it that the hair panel.
I promise you, I have.
I'm talking right now.
I'm sorry.
We don't, but we had trial on the 26th. All this stuff was due last week. We are on for a review on the 19th. This stuff needs to be into the court and filed and provided to Miss Winkles by the end of today. So by close of business, the clerk's office closes at 4:30 p.m. I would suggest you hang up the phone and immediately come over to the clerk's office, file whatever you have, make sure that Miss Winkles receives it. We're going to be back next Tuesday, the 19th at 1 p.m. to review this case. If I don't have what I asked for 2 months ago, I'm likely going to enter the orders that are presented by Ms. Winkles. She provided proof of service to you. You're claiming you didn't get that stuff.
No.
I would reach out to Ms. Winkles and make sure that you get copies of everything. But it does appear to the court that you've been provided all this information. So
yeah, no. May I ask a question real fast before I annoy you? I'm not trying to.
You're not
nervous.
Annoying me. Go ahead.
Okay, I'm sorry. I'm trying not to cry. Sorry, it's emotional. My daughter. Okay. So my SUD and my mental health right here. I'm looking at them right now.
Okay. They say assessments on them. They were not intakes, they were assessments. And I gave her the same paperwork that I have right here that I'm gonna give to you guys. Do I have to reprint them off and give them to her again? Because I'm confused on that.
I think you can, if you can confirm that you have the same things that you already gave her and that's what you're filing,
Yes.
you don't have to give them to her again. But if you have something that she's saying she doesn't have, then you need to make sure that she gets a copy.
Okay, yeah, they Columbia Wellness helped me separate everything for you guys and her. And
Okay.
everything is the same.
Okay. So that needs to be filed so I can review it prior to our review hearing next. And it's going to be a presentation hearing. And that includes any proposed parenting plan that you wish to file, okay?
Okay, I'm in Oregon City right now, so I definitely have to get a move on it. So.
All right, good luck.
Thank you so much.
All right, we'll
Thank you,
see
Laura.
that. And I'll, Ms. Winkles, I'll ask the clerk to hold these papers until next week.
It was
Okay.
All right, Anderson and Erickson, 233-0001508.
That matter's ready, Your Honor.
All right, and I see Miss Erickson present. And
I'm trying to make a bottle. I'm sorry.
okay. I have we were here last week and on the 12th, and I set this over 1 week to allow some information to be filed by Miss Erickson, and told her she needed to do that by the close of business on the 12th. Nothing has been filed.
I filed things. What? Nothing's been filed. I filed things. I filed everything in there. I filed everything. How is that even possible?
And so, Your Honor, just so you're aware of what
How is that possible?
I'm guessing what she filed. We did receive a mental health evaluation from May. It was the original one that I think that we were kind of aware of, but we hadn't seen. It was not collateralized. It's just Miss Erickson, her evaluation. There's no collateral contact with the GAL or my client or anything. It was the initial one that we hadn't seen, but the GAL said at the time, this is not collateralized. We need it collateralized. It was by that same contact that I had informed Miss Erickson that he would discuss it with her if she called him back. We did also get the hair follicle back. It was negative for everything, including Suboxone, which was really kind of shocking considering Miss Erickson claims that she's on 16 milligrams of Suboxone a day. So this is the second hair follicle that was negative for Suboxone as well. I believe Miss Erickson's argument was that her body's used to it, but that's not how it works. It still shows up. Buprenorphine still shows up in your hair. Unless there are those shampoos, I guess, that you can get to remove it, but they remove everything. So I am a bit concerned about that. At this point, I'd ask that either my parenting plans be entered as they are, the final orders, Ms. Erickson has received those, or that if we're going to do any sort of joint schedule, that my client maintain all decision-making ability, because there's been non-compliance the entire time. We had to go through so many contempts, so many things just to get here, that I am concerned that my client will be back in court next week, the week after, the week after. It's just not going to work. Miss Langford's here as well, the GAL. I know she's been discharged, but I'd ask the court to maybe weigh in with her. We've already had a trial on this. Miss Erickson has had every opportunity to get these things collateralized. This is not her first go round. She has had 3 other cases with other children where she was asked to get collateralized mental health evaluations. She didn't in those cases either. This is, there's only so much we can do. I've tried to be incredibly helpful. I called, her counselor. I said, this is what we need. He said, fine, have her call me. I told her, call him, he can help you out. To the best of my knowledge, I've received nothing that's collateralized. This is from May of this year. It's no changes. There's nothing that the court is very specific on. We want collateralized evaluation. You have to get this updated. It's easy. I just fear that nothing will be done as it should be. It'll all approximate something without going that extra level if we don't have my client have joint or sole decision making to everything.
Madam Clerk, do you show anything filed? I don't have anything. I have things that were filed after the 12th, but those were all filed by Miss Winkles. Are you showing anything that was filed that hasn't been scanned in, or?
Odyssey's loading, hold on.
I'm sorry, this is really odd. I filed them. I packed the baby up in the baby carrier and everything, and with my 4-year-old, we filed them.
So there's nothing new in Odyssey unless maybe she filed it this morning,
I put my whole entire life.
or if there were issues and it got rejected, but they would have called her.
Yeah, and I filed a parenting plan too, which is odd. I did everything that I was supposed to.
Well, I want to remind you, you
Like,
did
I'm
everything
shaking
you were
right now.
supposed to 2 months later than you were supposed to, but.
I know, I'm sorry. I do apologize with that. I was behind.
Well, that's part of the problem, Miss Erickson. I understand again how difficult this process is for somebody that's not represented. But we had a trial on this matter on the 26th of October. I gave you almost 2 months to get everything filed, and there's still absolutely nothing in the file. Absolutely nothing. And that doesn't work for me. I don't know how much more.
May I say something?
I'm talking, and when you keep interrupting
Sorry.
me, I can't tell you how frustrating that is. I've had that conversation with you so many times. I don't interrupt you. Please don't interrupt me. Okay. I can't tell you how difficult it is understanding the difficulties of navigating this the judicial system for this case. I don't know how much more accommodating the court can be, frankly. We had a trial. I could have made a ruling that very day, and I gave you an opportunity to provide information to the court. And I'm here 2 months later, and I have nothing. And I have information that Miss Winkles filed where she was trying to help you file this information, show you how to do that. It's email exchanges, you and back and forth that she's filed with me, telling you exactly what you need to do, and I still have nothing. So I am happy to hear from you. Please let me know why you have done nothing.
I have done everything. She has taken, okay, I'm confused because when Scott Roberts was a part of when he was my attorney, he told me that she had taken out everything that I had put into the courts because of some kind of it was when I was at the doctor's or whatever. And supposedly something happened and we weren't supposed to be able to tell you about it, about his criminal history, about the DV. Apparently I wasn't supposed to speak of any of it. That's what Scott Roberts told me. So I had to sit there quietly about that.
Report and the parenting plan and any of that.
And then with that, Scott Roberts, I gave him everything. I seen him on here earlier and it kind of irritated me. I gave him everything to turn in. He said he turned it in. He even gave me a declaration that he wrote out and he said he turned it in. Nothing had been turned in, and I'm just now finding that out. And I apologize. I can get everything else back in. If I can be given at least a few days, I can't. I've raised my child on my own. This is just crazy to me. Erin wants to come into her life when she's 3.5 old. That's fine. That's fine. But please don't take her from me. I've been trying to do everything I can. I did a parenting plan on my own. I did the law help one where they helped me do it step by step. I thought that was pretty cool because I didn't know that they did that. Requesting for him to have first, third weekends of the month and every other Wednesday. I just don't understand how none of them are in there. I have turned them in. I put my entire life on that. I'm really, really baffled and kind of confused, and I don't understand any of this. It's a bad dream.
And Your Honor, if I might, even if she turned those in, they're still not compliant. As I told her, that's from May of this year. It was not collateralized. None of it's collateralized.
It was collateralized.
I have that in my office. I can send it to the court and the parties. It was not collateralized. My client was never contacted. Miss Langford was never contacted. which is why she got the other email saying, you need to call, this is not collateralized, the court's very clear, it needs to be updated. So I'm not sure where to go. We were more than willing to try to do everything we could, but if we don't have the information, I'm not sure where to go from here, so I'd leave it in your honor's hands.
All right, Miss Erickson, now you can talk. Please let people speak and
sorry, I
then
don't-
speak. Go ahead.
I'm sorry, it's just, it angers me because that's not true. So when I went to Columbia Wellness to get the paperwork for you, what was it, a few weeks ago, to get my assessments, because she said they weren't assessments, they were, what did she say they were? Intakes? But they clearly state assessment and they were highlighted there. The lady highlighted it for her. And then that's the reason why it took a little bit longer to get to you, because, well, it should be in there anyways, because I had to go all the way back to Columbia Wellness because the Superior Court wouldn't take it with the highlighter on it. And I didn't know that. And I was speaking with the lady and I was just basically rambling like I am now and venting because I have nobody else to vent to about the situation. And she goes, well, that's funny because I had spoke to Mr. Anderson on the phone about this. He continuously tried to push that they are to contact him for collateral. And numerous times has he been told, and so has his attorney. My counselor even told his attorney. He told me this, that no, you are to call. The ROIs have been signed since beginning, have been signed. They've been done. All they needed to do was call. That was my fault for not telling them Columbia Wellness, because I initially at the time thought they knew it, because that's what Vashti told me was Columbia Wellness is where you get it done. I just had the baby, so I was kind of going through a lot, you know, and then plus having threats of my baby being taken from me when I raised her on my own. Anyways, and I was like, really? And then she continued to say that she actually had to send him to one of the bigger bosses, and I think his name's Chris or something like that. And Aaron continuously argued, trying to make that man say that no, we're to contact you, you're right. And he said, no, they told him that, the ROI has been done. You contact, and they've contact. I was told by that lady, and it showed in my account, supposedly that's what she said, was that they have already contacted over my assessments and stuff. So that's why I'm getting upset, because I'm extremely concerned on why people are lying so much. Like, I don't understand it. I have to be honest. And then receiving something about my child's doctor when I had already in the beginning, even Vashti knows that she goes not to child and adolescent. Like, where did that come from? Like, all this stuff that they're throwing at me when there's not supposed to be abusive litigation, that's said on my protection order. It is stated by Mary Hahn, because that's exactly what he does. And that's why I'm upset. I'm trying to calm down. I'm sorry. This is what Aaron does. It's just like, it's been one thing after another after another. I've done what I was supposed to do. I thought Scott Roberts did what he was supposed to do. He took $5,000 from us, and we worked hard for that. I don't have that. I can't afford that for another attorney to show that I'm being honest. So I'm trying to use my voice, and it's so hard to do this right now. But everything that has came out from Ms. Winkle and Mr. Anderson is just completely baffling. It's not even true. Like, I don't even understand it. Like, why? My child goes to Vancouver Clinic. She has since I gave birth to her, like.
Okay.
I'm so sorry.
couple different, thank you, Miss Erickson. I understand your frustration. The clerk asked of, she's in the courtroom, she asked of the folks in the office if there was paperwork filed. They indicated that there was paperwork filed, but they weren't, or brought in. They were not filed because they all have the wrong cause number on them. So I asked if they could be brought to me, and that's what I just received. I obviously have not reviewed them. They all have the incorrect cause number on them, the parenting plan, and it looks like some healthcare records. Is that what you received, Ms. Winkles?
It is, Your Honor. And just so you're aware, Miss Langford has her hand up. I'm not sure if you can see that.
No, I did not see that. Ms. Langford, if you want to jump in here, by all means, go ahead and make your comment.
Yes, I'm sorry, I don't have camera ability. I'm at OHSU where I've been pretty much every day since Thanksgiving. So I just want to clarify some things. I've never, ever received confirmation that I am on RI for Columbia Wellness, as it states in my report. I've called and they keep telling me the same thing, that I am not on the RI. I've reminded Miss Erickson I need to be on there for collateral. I've not received any documentation from her since way prior to the hearing or to the trial. I still have not been contacted for any additional assessment since the one we've seen in May. Her attorney actually asked me for documentations and said he had nothing from her prior to him removing himself from the case. I gave him what I had. And I'm honestly probably equally frustrated because I've given reminders that this needs to happen, this needs to be done prior to the trial. And honestly, I have medical things with my family to deal with, and having to be dragged back and forth because we're still not getting what we need is very frustrating for me. Because I want what's best for the child, and we're not able to do that right now because we're not getting what we need. And I've not received anything from Mrs. Erickson since way prior to the actual trial that we had.
And I appreciate that, Ms. Langford. Can I just ask a follow-up question? I know that you were present at the trial that we held back in October of this year, and at that point made recommendations. Is anything about the recommendations you made at trial back in October, has anything changed, I guess?
No, I think that I at this point I would agree with anything that you're recommending, because we're just not getting what we need to verify any information, and we're all coming back to the same courtroom for the same responses, and we can't say what's best for a child. We don't have all the information, which is what we're not getting.
All right, I appreciate that. Thank you. Okay.
May I say something? I can pull it up on my phone even. Vashti's been in there since I did it all at the same time. Why wouldn't I? I did. I told her, I even have an email from Vashti that said, I was like, what else do I need? And she said she had everything from me. I have that in an email. I can, if I could send it over to you right now, I would. And I should have printed it out. I had a feeling to print it out, but I've been having to use my boyfriend's work because he's a mechanic and we don't have a printer in the apartment. So I've been trying to, find out ways of getting you those documents. I swear I have put all my ROIs in. That was my major deal. Like, that's a huge deal. Why wouldn't I? Like, that's my baby. I don't understand what's going on. It's like a really bad dream right now. Like, really, really, really bad. Because if I could get you everything, I'll give you all my whole profile. It shows exactly the dates when I put those ROIs in. It shows the dates and the times. And they have been in there since way before May. And I'm sorry to overtalk. That's why I needed an attorney, because I don't understand a lot of this stuff. But I need them for my boys because I'm not good at what I'm sorry, my 11-year-old's blaming me. Lexi, go sit down, please.
All right. Here's where I'm at. I kind of echo Miss Langford's comments, because I feel like even though we went through a trial, there wasn't a lot of information at the time. Mr. Anderson hadn't even, I don't believe, started any kind of weekend visitations. And I believe that we were progressing towards those with the help of Miss Rosen and her working with the child here. And but at some point I feel, I do agree with Miss Erickson that this is kind of like a bad dream, because I feel like it's the same issues repeatedly over and over again. I'm reviewing my notes and I'm reviewing the minutes from the trial, and very specifically, there was a discussion with Miss Erickson that she needed to sign ROIs because those had not been done, and that the mental health evaluation that was done prior this year would not be appropriate because it was already at that point over 5 months old, and a new evaluation would need to be done that was collateralized. We've done nothing. So we haven't even been able to do that.
I'm gonna be honest.
I'm gonna talk. I don't know if Miss Erickson just chose to zone out when the court was making the rulings back in October.
I didn't hear
But
it.
all of the, I'm muting you because you keep interrupting me. So please don't unmute unless it's your turn to speak. Very, very clearly in my notes, in the minutes, it was discussed that release of information need to be signed for all the parties so they can all be contacted for input. And it sounds like the only thing that she's done is the hair follicle, which is great. And I'm glad that that came back clean. I agree with Ms. Winkles. There is some concerns if she's claiming she's on a Suboxone program and it's not even showing that. That is a concern. That doesn't just, I get immune to a Suboxone, so it's not in my hair. That's not how that works. She did inquire of the court whether she could file a proposed parenting plan. I said, well, you can always file a proposed parenting plan. So now I just now received that after asking the clerks to have it brought back to me, even though it's under the completely wrong cause number. So I feel like I'm extremely frustrated. I don't want to suggest at this point that Miss Erickson is a bad person, a bad mother, but I do find that there's some definite concerns about what her cooperation level would be like on any kind of parenting plan with Mr. Anderson. She claims that she wants Mr. Anderson to have visitation and to do all that. I'm just concerned whether how that would go. Her proposed parenting plan, and Ms. Winkles, you indicated that you did have this copy, so that's why I'm referring to it. Basically says that he has to comply with treatment and that he would get the first and third weekends of the month. And that's school age and non-school age. And that's pretty much it. Your proposed parenting plan.
I meant to put Wednesdays on there. I redid another one and it deleted completely. I'm sorry.
Your proposed parenting plan basically has, it's the extreme in the other direction that,
it is a phased in approach. It's an extreme until she gets the collateral mental health. And I believe it moves to more of what Your Honor was talking about in the trial, the 50-50, but without that collateralized mental health, we had the extreme. We had two actually filed.
we've had weekends with Dad.
Yeah, yes, he's had overnights. I believe he just had the last weekend.
I did have my overnight this last Saturday.
All right, so, I do recall, we just have layers. I understand Miss Erickson probably is a, stressed out, single parent. I know that this is not her only child. I know there's a lot going on. And this, it's hard to prioritize things, but obviously this was a pretty, major situation. I have, proposed orders that Ms. Winkles has provided. What I'd like to have happen is so I'm gonna adopt the orders. There's one thing I'm gonna take out the 191 of substance abuse as it relates to Miss Erickson in the proposed parenting plan. She's a clean hair follicle. There was a history, but her claim is that she's been clean for I believe she said 6 years. So great. I'm gonna take that out of the mix here. So I'm gonna sign this parenting plan. So what that means, Miss Erickson, is you're gonna have visitation with your child until you get that that evaluation done. And then once that evaluation is done and it's collateralized, then my hope is that we'll move to a 50-50 parenting plan. But you have to get that evaluation done. It has to be collateralized. That includes Miss Langford, Miss Winkles, Mr. Anderson. Those people have to have that information. Once that information is provided to the court, then we'll have another hearing and adjust the parenting plan based on that. Is there a visitation that was scheduled for this weekend? Or when was there another
We were
visit?
going by Charlotte. We were going by Charlotte.
Mr. Anderson, was there one for this weekend?
We were waiting for what the court hearing was going, and Charlotte wanted me to contact her after the
All Ellie knows is
knows everything.
you're hurting my child.
I hope I'm not hurting your child, ma'am, but I
No,
can't
not you, not
feel
you,
well.
not you, not. I wasn't talking about you. I wasn't talking about you. I was because he was speaking, and I was just saying that because he never tried until I got pregnant. So it's like I raised my baby on my own.
I'm not suggesting that you haven't put the work in, but there's concerns here that have been raised by multiple individuals.
I really
There's
didn't hear
multiple
the.
things going on. There was a.
I had the baby, and I was going through.
Okay.
I went through postpartum.
I'm done at this point. I can't argue over the top of you. I've made it known in several court dates what's been requested of you. I've tried to give you ample opportunities to get that done. I, again, am not in any way indicating that you're a bad person or a bad mother, but there are things that the court's ordered that you've basically just ignored. So we have a healthy relationship that's been established between father and child. And my hope is we'll get to a 50-50 plan, hopefully within the next few months. And this is a temporary situation that we're in. But I'm going to indicate, and there is an indication on here that once that evaluation is done and that there is, you're going to have 60 days to get that evaluation done. That doesn't mean the report has to be done in 60 days. That means it needs to be set up and
It's just minimally
let me rephrase that. Doesn't mean the actual evaluation, like the final report from the provider needs to be done in 60 days, but the appointment has to be done and made within 60 days.
I'll do it.
And
This week,
then
next week.
I'm just going to indicate in here,
Please.
I want to make sure, Ms. Winkles, and please point it out to me if it's in here already, that that this, and I don't know if you want to just set a review date, or that Ms. Erickson can bring it back for reconsideration once that evaluation is done.
I believe it says that she can motion the court the moment it's done, but if I haven't put it in there, that's what I would suggest, just so we don't come back and it's still missing and it looks bad. Maybe as soon as she gets done, if it's done in a week, if it's done in 3 weeks, however long it takes, she can just stick a motion in the court and we can come back. I thought I had it at the end of the evaluation part that she has to do it in 60 days and then she can motion the court. Otherwise it stays the same. But I've done so many parenting plans for this case. I'll be honest with you.
Right.
I can't remember.
It does say, okay, so Ms. Erickson, listen very carefully. It says, after obtaining the relevant evaluation, you can petition the court. And I'm going to say petition the court, and it says to begin weekend visitation. And here's what I'm going to do. I'm going to change the language here. So after obtaining the relevant evaluation, the mother, and this is going to basically be an agreement between Miss Erickson and Miss Winkles. The mother may.
Can I get my custody back?
Can you hold on?
Is there a way to do that?
The mother may begin
sorry.
weekend visitation. So evaluation's done, mother starts weekend visitation. Once the evaluation is done and all the parties have received the report, then mother may petition the court for a change in the parenting plan without an adequate cause finding. So what that means is that once we have the evaluation, everybody's seen the evaluation and been able to weigh in on the evaluation, you come back to court and then we look at the parenting plan and decide what is best moving forward. Once we have that information. Once you've done the evaluation, your weekend visitation would start. Does that make sense? Okay.
So after acknowledging, sorry.
Go ahead and ask the question, Ms. Erickson.
I'm so sorry.
Don't apologize.
After I do the collateral, I don't have money for an attorney because that man stole our money. I don't know what to do. I raised her. Like, when can I get her home? That is my baby. It's our baby. But exactly, he just now came into the picture.
I understand that, and that's why we're dealing with it. So I'm not ordering any fees, so I'm striking any judgment as requested, so I'm not imposing any fees. And okay, I'm going to mute you again here, and we need to keep our record. See here, there's a child support order in place. Ms. Winkles, I'm going to table the child support order, and after 60 days, if there's nothing, then I'm going to enter the child support order. Is that fair?
That's absolutely fine. And Your Honor, just so you're aware, we'd be okay with her filing just a motion rather than a petition. Just because I believe since she's pro se, my client he wants to be easy, but he wants to have the information is really where we're at. So we're fine with a motion rather than the full petition, because that might be a little bit more confusing for somebody who's pro se.
Okay. I don't even understand any of that right now. I'm sorry, I don't. My brain's just.
I understand that, Ms. Erickson. I would remind you, and I'm assuming Ms. Winkles, you're going to stay on in this case.
I am, Your Honor.
Everything that Miss Winkles has filed that, about your interactions, have done nothing but indicate to at least me that she's trying to help both of you through this process. So if you have a question, based on what Miss Winkles has indicated thus far, I think she would be willing to at least try to answer those questions for you. She can't obviously represent both of you, but I've changed that to may motion the court. So that means you just say, I need to have a hearing in front of the judge about my parenting plan. That's, and you come in and the clerk will help you and you file that. Make sure it's on the right cause number. And so you know that we're under the cause number of 2331508. The child support orders, I am going to set aside. So I'm not ordering any child support at this point. After 60 days, Miss Erickson, I want you to be very clear. If you don't do anything after 60 days, then this is just going to be the order. Okay.
Yeah, that's not good. That's not possible. And I'm going to make sure that I'll put 3 copies in. And if anybody takes it out, then I don't know what else to say.
I'm glad to hear that. And again, once you get that process started, it sounds like Miss Winkles will help you ensure that everybody's on there, everybody's doing what they need to do.
I can't trust her. I'm sorry.
Okay, well then do it on your own, I guess.
No, I need help.
I don't know. I can't give you any legal advice. So from sitting on the bench, I can't give you legal advice. There is the Northwest Justice Project. There is Cowlitz County Legal Aid. I don't know where you reside. If you reside outside Cowlitz County, you can contact your local legal aid. But there are services available on Mondays and from 12 starting mid-January, Mondays from noon to 2 p.m. There's a free attorney that's here at the courthouse that you can come and talk to. I'm sorry?
Can I bring my little baby with me?
Of course.
Or is that?
Yes, no, it's not in a courtroom. It's just in the lobby in a room off the lobby of the courthouse. So if you need to bring your children, of course, you can bring your children. We'll get all of this process started. I'm gonna ask that this be filed, your information be filed with a cover sheet with a proper cause number on it. So it shows that you filed something. Okay, Miss Erickson, because I want to make sure that, you know, you obviously attempted to, but it has the wrong cause number. So I'm going to ask that they file it with the correct cause number on it.
I accidentally put the protection order cause number, and I apologize for that. I didn't realize.
That's okay. I'm going to ask that, I don't know if,
how am I going to
I think Miss Rosen is probably going to need to, any counseling sessions that we can set up in the next week or two are probably appropriate. I would like the exchange to happen if at all possible. So Miss Erickson would exchange the child with Mr. Anderson on Sunday, the 24th, no later than
there's a protection order. Can my dad do it?
6 p.m. Absolutely. Okay, so I want you to have some time on, and if you want to, if the parties agree to a later time on the 24th, that's fine, but the exchange on the 24th, so mom gets Christmas Eve and then dad will have Christmas Day, and then we're going from there, okay?
Your Honor, I just want to say, if she needs help with things that I can help with, I'm totally willing to help her. But I can't help with everything, obviously, but I'm willing to help where I can.
I asked you.
Well, Miss Langford's indicating that she's willing to help you. I don't know. I understand you're frustrated, and I don't understand you don't like the court's decision, but it's time we need to get this sorted out, and you need to follow through with what the court requested of you 2 months ago. So that'll be the order of the court. If it needs to be brought back, any other presentations, or if it needs to be before me, that'll have to be Fridays come the new year.
All right. Thank you, Your Honor.